You're tuned into Economic and Political Weekly's new podcast show, Research Radio. We hope to bring academic rigor to ask and address complex questions. Our show lets you learn directly from researchers who are at the forefront of their fields. I'm Abhishek, your host, and today I'm going to be speaking to Dr. Jason Fernandes. He analyzed the much celebrated 2018 Supreme Court ruling that decriminalized queer sex. Dr. Fernandes shares with us why we should be more cautious about the liberation it appears to offer. This podcast is based on the arguments he presents in an article published by EPW in January 2020. But first, a little bit about him. Dr. Fernandes is with the Center for Research in Anthropology, ISCTE Lisbon University Institute in Portugal. He holds degrees in law, sociology, and anthropology, and his doctoral study focused on the citizenship experience for Goan Catholics. Thank you so much for joining us, Dr. Fernandes.
It's a pleasure, Abhishek. Thank you.
Would you like to start by telling us about the September 2018 Supreme Court ruling that overturned Section 377?
This decision in 2018 came at the end of a rather long-drawn legal battle against Section 377 of the Indian Penal Code. So as you know, Section 377 of the Indian Penal Code, or the IPC, essentially criminalized sexual activity that was against the order of nature. The argument of legal activists was that against the order of nature was being interpreted to mean homosexual penetrative activity, and this was being used by the police to penalize essentially persons who were having sex out on the streets. So sex workers and even persons who, let's say middle-class persons who, for lack of any private space, were engaging in sexual activity outside of in a public space, right? Essentially, what the decision did was to approve what had happened in the Delhi High Court decision, saying you cannot criminalize same-sex activity, and read down Section 377 to that effect. So as a result, same-sex activity cannot be the basis for criminal prosecution in India anymore. So this was the decision, and everyone went crazy. They thought it was a great step forward in terms of queer rights. And so this is the context within which I wrote my piece.
In our Notes from the Field segment, we'd like to learn about your research process and why you chose to focus on details about the judgment to make your argument.
I thought that when the decision came out, I owed it to myself as an academic to have a look at the text and see what exactly are they saying. Because invariably, especially in the kind of 24/7 news cycle that we've become accustomed to, sound bites come out instantly and everyone's acclaiming a decision. I mean, we don't even know what it's saying, right? And also the Indian Supreme Court has this great knack in producing huge judgments, and a lot of it is just opinion. Actually, it's sometimes also uncalled for. But then all of these kinds of things then start impacting later decisions. So I wanted to see what exactly they're saying, and also to see what they were saying. What was the details of what they were saying in the way in which they were framing the argument to decriminalize 377. For example, I was always concerned about the way in which same-sex activity was being, or let's say the criminalization of same-sex activity in India was being presented as something owing to Victorian, Christian, and Muslim sensibilities, right? So I wanted to see if this, and I could see the activists making these arguments, and I wanted to see if the court was picking it up, if it was silencing those arguments, or if it was building on those arguments, right?
Why was it useful for petitioners to frame homophobia and transphobia as a British colonial import and a product of, quote, Judeo-Christian values, end quote?
This argument of saying 377 has everything to do with Judeo-Christian values and nothing to do, therefore, with Indian values was the kind of nationalist plank on which the argument was being presented. So it wasn't a question solely of rights. It was also a question of recovering national identity. It became a question of decolonizing our law. Yeah. And so you very neatly they present, it's almost that everything bad in terms of our sexual lives is the result of colonial intervention. So let us decolonize and go back to the glorious India of the past. Almost this is pretty much the implication of the argument, if not actually stating it as much. Which I think is hugely problematic because, for one, for one, this whole concept of Judeo-Christian is something that is fairly new. It emerges, let's say, in the interwar period between the world wars, gains strength in America, especially in the Second World War. And subsequently, when it is presenting itself as this a country of religion against the godless communists, right? So this idea is fairly new. Two, within Christian communities itself, there has been a huge amount of discourse. So you must understand that Christianity itself is not static. It's a dynamic religion. People are constantly having discussions. So people pointed out that, for example, the story of Sodom and Gomorrah, which, if you go by these legal activist arguments, is the basis for 377. Biblical scholars point out that the people of Sodom and Gomorrah were punished not because they were trying to have sex with, or men were not trying to have homosexual sex, but because the men of these cities were trying to rape travelers, right? So they are violating a fundamental obligation in the Middle East, which is open your tent up to persons who are traveling, people who are vulnerable. Right. So it was for this grave violation that they were punished, not necessarily because they were engaged in homosexual activity. Then there are others who also point out the kind of Christian obsession against homosexual activity can also be traced to the Roman Empire and the way in which sex as pleasure involved the use of the bodies of slaves or the disrespect of individuals, right? So this is the context in which it emerges. So to not look at this context and to present 377 as emerging from this kind of sex-obsessed Christians, I thought was to do a disservice not just to Christianity but to Christians in India, right? Because what you do when you say that 377 is the result of a colonial imposition, and this colonial imposition is a Christian sensibility. What you are also suggesting is that Christian sensibilities in India are not quite Indian, right? So this is a huge problem for Christians, and it delegitimizes their presence in the country. Now, most of secular debate in India invariably happens between these two poles of Hindu and Muslim. So the poor Christians invariably get edged out of the debate and the discussion. But I think it's important to talk about these communities as well. Yeah.
And right, is this linked to the forms of modernity that India is striving to achieve?
What Indian modernity and Indian secularism tried to do was they'd say, yes, we're open to everything. We're open to the world. Yes, we have unity and diversity, and we'll allow Muslims to do to sing a kavali, Christians to sing Abide With Me. But all of this has to happen within a larger Indian context, and that Indian context just happened to be North Indian upper caste norms, right? This is Indian modernity, and which is why I think this whole project of Indian modernity is deeply flawed, because it's essentially soft Hindu nationalism. A lot of the legal activists who have pushed against the criminalization of 377 would see themselves as secular nationalists, right? If not even Nehruvian secularists. And this is perhaps where the tragedy lies, is that they themselves don't realize how much of Nehruvian secularism already encodes a certain kind of Hindu dominance, right? And the last bit I just want to say over here is that I want to make it very clear that the problem over here is not with individuals. The problem is with the larger structures within which we operate, right? The problem with the individuals would emerge once we realize how the structure operates, once the argument is presented to you. Then if you still choose to kind of deny the existence of this model, that's when you can pin individual guilt, as it were. But I'd rather like to focus on the larger structures that have allowed us to get to this position.
How did petitioners and judges appropriate the struggles of Bahujan low-income transsexual groups to gain, quote, cultural rootedness, end quote, while not concurrently naming the forms of violations against different groups? What is the significance about locating violence on the British colonial laws rather than contemporary and pre-colonial forms of violence?
Right. In fact, I was galled by this particular argument because so much of the mobilization against 377 has happened on the backs of marginalized Indian communities, right? Whether it is the hijras, whether it is sex workers, and all of this is playing out in the public, right? And in the public arena. And legal activists use these kinds of testimony, and then all of a sudden it switched so that the rights of middle class queer persons is affirmed, which in any case in practice wasn't greatly challenged, right? It was really on the ground police violence against marginalized communities was the original problem, right? And so this is not acknowledged at all, and you start placing these limitations on the right. Now, I am not making an argument for let's say for sex on the streets. This is not at all the argument, but the argument is you need to specifically recognize that police violence in such cases is entirely unacceptable, and there is not a whisper of this police violence at all in the judgment, right? So this is where I think the problem lies: is you use the testimonies of the marginalized, but use it to support the rights and benefits and privileges of dominant caste and upper class persons in the country.
Are there other examples of appropriation you'd like to share?
But I just also want to make reference to that film I saw years ago. It's called Between the Lines: India's Third Gender, which focused so much on transsexual persons who live on the margins of society. And so you have this entire discourse, and then, for example, in the judgment, the sympathy for the court is given to the petitioners who were alumni, if I'm not mistaken, or students of IITs, right? Now, we know that the IITs are the location of caste discourse in contemporary India, because it is around the IITs and reservations for SC, ST, OBC groups that we have huge amount of discourse against reservation. And so the IITs emerge as this location of merit, right? And those who get in through reservations are assumed to be lacking in merit. So this I thought was really interesting, that we use the experiences of persons from the margins of society, persons who are either from marginalized communities or who enter marginalized communities because there's no space for them within their own caste or class groups. You use this experience, and then you switch around and you talk about the poor students from the IITs, which largely are dominant caste, or embody a certain dominant caste behavior or habitus. Yeah.
How have Bahujan, low-income, gender and sexual minorities countered the claims made by dominant queer activists, particularly in the post-2018 period?
Even after the Supreme Court decision in the Navtej Singh Johar was announced, and while people were busy celebrating, there were persons from marginalized communities, transgender activists and others, who did issue a few statements indicating that not everything is clear, because without basic rights, without the protection of dignity, protection against police harassment, this decriminalization of 377 means nothing. Or does, okay, maybe I'm exaggerating. Not that it doesn't mean nothing, but it still remains severely limited. And I don't have cases to offer offhand, but I've been looking at the way in which there is a reporting about certain things, and one still sees how, for example, recently, if I'm not mistaken, in Rajasthan, I think a minor boy raped another minor boy, and rather than frame it as rape, the headline of this report framed it as unnatural sex. Right. So clearly, there are still problems in the way in which we understand these issues that need to be resolved.
Many newspapers and activists praised the judges for their ruling, and you've noted specific ways in which the judgment is really limited. The judges include qualifications or terms and conditions to access the rights they appear to offer. These include, quote, indecency, public order, confined within the most private and intimate spaces, and dignified environments, end quote. Can you tell me more about these conditions that have been inserted by the judges and what makes them insidious?
Abhishek, I doubt that India has a notion of public order or common notions of what decency is, because you have such a variety of caste behaviors, class behaviors. And a good amount of the problems in India lies with the fact that we, rather than trying to articulate it through conversation, very often notions of decency and public order are imposed via police violence, right? I seriously doubt we have an appreciation, and if at all there is a notion of public order, it's one that has been imposed by violence, whether police violence or state violence, no? Where notions of public order are ones that are essentially convenient to upper caste persons. Let's take the way in which drinking alcohol is problematized in India. Drinking alcohol is not a problem for Christian groups, not a problem for what is normally called lower caste groups. It is not a problem for Adivasis. And yet, there is this larger kind of notion of what public order is, and which is that no, that you cannot have alcohol is seen as this the consumption drinking alcohol is seen as the consumption of problematic substance. So I disagree that notions of public order are clear and defined, and I think this is one of the problems of the judiciary in India, is that there's just this easy assumption of a variety of norms which actually doesn't really exist. And of course, the Indian judiciary is by and large seems to be innocent of the nuances of how society operates. So there's this very clear, very kind of positivist understanding of what is law and how it has to be imposed. So I think on those lines, this is a very, very problematic judgment. So, when we talk about how this myth of a golden pre-colonial India is created, very often it's become commonplace now to mock Prime Minister Modi and other leaders who say, "Oh, listen, we had plastic surgery, we had airplanes in the Vedic or the epic period." But I mean, these are clearly ridiculous or exaggerated claims. But there are other persons who very subtly and very kind of in a smooth manner try to create this idea of a wonderful pre-colonial period. One can just take the example of Devdutt Patnaik, who tries to offer these readings of Brahmanical myths and mythologies. So the idea is, okay, so if it was there in the story, it kind of reflects a social reality. But when they discuss this, when they discuss these myths, they don't talk about the presence of caste. They don't talk about how it could merely be a narrative that is being used. Or they don't talk about, for example, just take, you have Brahmanical mythology that talks about transgender or what seems to be transgender characters. But there is no talk about the other aspects of this reality. For example, I mean, Patnaik himself acknowledges that the Dharma Shastras privilege heterosexual marriage, that they only grudgingly accept or acknowledge the existence of sexual practices that are against procreation. So there is no kind of acknowledgement, or they don't allow it to impact upon their analysis, because they're so focused on creating this idea of a golden pre-colonial period, which is, as we've already discussed, hugely problematic. So I think to have used these terms of decency, public order, innermost space and such like is hugely problematic, because for a number of people, you do not have a private bedroom in which you can retire to, right? And this is where the problem emerged in the first place, where sexual activity would happen in public bathrooms, and this was a great place to for the police to pounce on persons who are just looking for a little bit of privacy.
Yes, you have. And just moving to the last question of our show, and it's one that we ask all our guests, is what do you see as the role of academic research in furthering equity both inside and outside institutional spaces?
I'm hoping that either through the sharing of the text, this issue will be debated more, and the issues of caste and class will impact more on the way in which we appreciate both sexual politics in India as well as the other politics, because all too often caste doesn't really feature in our analysis. I mean, we may mention caste, but caste doesn't really become a part of our analysis. It's just there. It just floats on the surface without impacting on the way in which we understand the Indian polity. I mean, I just give an example of Soumya Brata Chowdhury is an activist who has just recently been making very interesting arguments, and one of his arguments is that you can't have a society in India where the polity is so marked by caste, and he says caste operates as a gang. I mean, and he's following Ambedkar on this, right? So, I think this is fundamental to the way in which we understand the way the Indian polity operates. Is that very often even academics casually use the word Indian society. But how can you have society where caste is so fundamental, right? Where caste impacts on everything you do, even if you are in the urban world. Yeah. So I hope that this text would draw attention to the way in which caste impacts on things that seem as far removed from caste as the rights of homosexual activity.
Thank you for joining us again, Dr. Fernandes.
Thank you, Abhishek. It was a pleasure.
What I found quite important from what he had to say was about how judges inserted all these qualifications based on supposedly common sense terms like public order, as though we have this one conception of public order that is free from patriarchy, casteism, homophobia, transphobia. These insertions have implications about the kinds of queer people the state and society deems acceptable, specifically upper caste, cis male, middle class people. If you'd like to learn more, read the full article by Dr. Fernandes that I've shared in the description. Next week, we'll hear from Professor Anupama Roy about the radical changes brought to India's citizenship law last December that makes religion a basis for providing citizenship, and its awkward cohabitation with the ordeal to establish citizenship in Assam. We'll focus in on a parliamentary report that seeks to justify the law in multiple and sometimes very contradictory ways. To make sure you don't miss out on that and our future podcasts, make sure to subscribe to us on your favorite podcast streaming platform. We're available on Spotify, Google Podcasts, and Apple Podcasts. And since we're new to podcasting, we would love to hear from you about how we're doing. Do send us an email at social@epw.in or ping us on Facebook, Instagram, or Twitter with your feedback. And if you like what we're doing, do share it with interested folks. Take care, and until next week.